I'll share the presentation and hand it over to Jose Luis, who will start the session. Okay, thank you very much for joining us.
Hello, welcome everybody for attending this webinar about as explained by Cristina, about the new regulation of the telework. The objective of this webinar is to give you the key points of the Royal Decree 28/2020, which was published a couple of weeks, and that is in force from the 13th of October. In this first part of the presentation, I'm going to explain the precedents of the remote working in Spain, and then my colleague Clara will introduce the key points of the new law. One moment. No. Sorry, I have a problem with the. Doesn't work. Now, okay. Okay. Prior to the COVID-19 pandemic, the remote working was not regulated in Spain. The first regulation about this matter was the European Framework Agreement on Telework, negotiated in 2002, and to be implemented by each country. Until now, Spain didn't regulate this matter. This European agreement already established most of the conditions now regulated by this new regulation in Spain. Some of these features are that the teleworking is voluntary and reversible for both sides, employer and employees. Teleworkers benefit from the same rights as comparable workers at the employer's premises, and another general rules established in this European Framework Agreement is that the employer is responsible for the written information to the teleworkers when engaged in telework, data protection, providing, installing, and maintaining equipment, cover costs directly caused by telework, or providing appropriate technical support facilities, and also health and safety. As you will see later, all these conditions are included in the law approved by the Spanish government. And apart from the above mentioned agreement, remote work appears briefly in the usual employment law. In Spain, as you know, is you probably know, is the workers' statute. In concrete, in the Article 13, stipulates that remote work is that in which the work is performed predominantly at the worker's home or at a place freely chosen by the worker as an alternative to working at the company's premises. And also in the Article 34.8 establishes that workers have the right to request change regarding the number and distribution of working hours, scheduling the working time, and the form of work, including remote working, in order to exercise the right to work-life balance. Esto no va. Así es. Sorry. In another law, Spanish regulation that appears this or is mentioned, the the telework is the Organic Law 3 2018 on the protection of personal data, which establishes the right to privacy in the use of digital devices for work and the right to digital disconnection. In the next section, I will explain how the pandemic forced many companies to implement that remote working from one day to another, which I suppose is your company was in the same situation. COVID-19 pandemic was an unprecedented situation in Spain, the same in the rest of the world. And in Spain, the government published many regulations to reduce, in order to reduce the impact of COVID-19 on the economic, and decreed the state of alarm in the middle of March. On March 17th, was published the Royal Decree Law 8 2020 on extraordinary urgent measures to tackle the economic and social effects of COVID-19, and in concrete, in the Article 5 was established the preference for remote work. This was one of the reasons to send employees home to work remotely, as long as their functions make it possible. On the other hand, in Article 6, known as Plan Me Cuida, establishes that employees can adapt working hours or any other employment conditions to take care of children or relative up to second degree, and these include change working on premises to remote working. So these two articles were the base or to adapt the telework in most of the companies. One moment. As a consequence, and this will be explained by Clara later, the companies that adapted the telework due to COVID-19 continue being subjected to the usual employment regulations, the Workers' Statute, and not by the new Royal Decree 2028-2020 that regulates the telework in Spain. Sorry. Sorry. Because of the in this section, I will try to explain to analyze the experience of teleworking during the pandemic. As a interesting data, because of the pandemic, remote work in Spain went from 55% to 34% during the pandemic. Okay? This kind of work system implies some pros and cons. As pros, we have greater flexibility regarding working times and breaks, greater possibility of self-organization, target-based work, improve work-life balance, lower cost in offices and saving on transport, increase productivity and rationalization of working hours, distribution of the population throughout the country, especially in rural areas, and attract and retain talent. and reduce absenteeism. On the contrary, esto no va. On the contrary, as cons, there are data protection security breaches, techno stress, non-stop work days, or information fatigue, permanent digital connection, increased work and social isolation, loss of corporate identity, fewer opportunities for training and teamwork, transfer of work-related costs to the worker with no compensation, imbalance in rights and obligations between companies and workers, or difficulties to control and monitor work and teams. These cons are the base of the new regulation on telework, and this is one of the reasons why the trade unions have negotiated with the government this new regulation. And now I give the floor to this is when I finish with this part, and now I give the floor to my colleague Clara.
Clara, you are on
Hello,
mute.
Clara.
We cannot hear you.
Hi?
Yes, perfect. Thank you.
Bye. Sorry.
Yes, thank you.
So thank you, José Luis, for your presentation. Right, in this section, we are going to talk about the main aspects of the new law. And in line with the above commented, and due to the pandemic situation, it was required to regulate the remote work system and establish legal basis to define the legal framework of this measure. In this regard, as all you will be aware, the government published the new law on remote work. This regulation not only sets the basis to implement the remote work but regulates also related subjects that could be affected on the application of the measure in order to preserve and enhance the. So in this section, we are going to talk about the more relevant implications that the new law involves. First, and regarding to the employment implications, it should be noted that the implement of the remote work system, it's compulsory to reach between the company and the employee. This agreement that must be in writing has to be formalized prior entrance into force and has to fulfill stringent requirements that will be introduced shortly. At the same time, the implementation of the remote system cannot imply, by no means, a clear discrimination or an unequal treatment between men and women. Those employees who opted for the teleworking will keep the same rights as per the ones on-site working employees, and their working conditions will not change owing to the remote working implementation. Those employees that choose operating off-site will be able to get from the company the means required to develop properly their job functions. In this regard, the company will also have to cover the costs incurred during the remote working, since this measure should not involve additional costs for the employee. Maybe this matter will generate many doubts because the law do not define clearly which cost has to be remitted and how by the company, but as it should be treated as personal expenses, these costs will not be subjected to the social security contributions or retentions on income tax. Likewise, the use of the telematic media and the automatic devices to regulate an employment relationship will have to guarantee that the rights of the employees are respected, and most especially the rights to privacy and personal data protection. In addition, the companies have to necessarily ensure that the health and the safety regulations are being of application on remote working employees. The risks of this kind of working systems has to be evaluated with particular attention, of course, to the psychological, organizational, and ergonomic aspects. As all you can see, there are so many features involved in a remote working systems implementation that it will be wise to create and introduce in an internal policy of remote working in order to regulate jointly all these elements as per the same for all the employees of the company. Okay, and now who's going to be affected by this law? So it must be said that the new remote working law will only be of application for those employees that in a period of 3 months are working at 30% of the working time off-site remote working system. For the employees in under age of 18 or with an internship contract, it could be set just 50% of the working time as remote working. The remote working system will be implemented voluntarily. That's really important for both employer and employee. So that's to say, from the moment that one of the contractual parties decides to solve the agreement and restore the working system to an on-site system, the law allows to revert this agreement, meaning that the refusal to remote working system implementation or to the reversion to the on-site working system will not entitle to extinguishing the employment contract. And that's an important aspect. Okay. In order to regulate individually the remote working measures, the company and the employee must reach a written agreement, as told before, with a minimum content, including an inventory of means, a list of quantified expenses, working time and availability topics, proportion of remote work, the part of remote work, company workplace, remote workplace, notice period for reverting, employees monitoring, procedures in case of technical difficulties, and so on. The law completed just an exemplificative list of the minimum content of the agreements, but do not develop each point. So it is going to be done in the collective bargaining agreements. So the purpose of the law is to guarantee the equal treatment of the employees who opted for remote working to those employees working on site. According to this, the law kept all the rights of the employees, like the right to promotion, health and safety, a right to privacy and data protection, and so on, increasing at the same time and adding new employers' obligation in order to preserve and ensure that the employees' rights will not be affected by the new measure. The law regulates the general features of the remote working system, and the development of these elements must be done by the collective bargaining. To this effect, the collective agreements, accordingly to the specific activity of each company, will set those job titles and roles most likely to be done in the remote working system, just as the working conditions, the maximum duration of the remote work, the way to exercise the right to revert, and so on. And in addition, as mentioned before, the collective bargaining will regulate also the expenses compensation. It's fixed that by collective agreement, it could be established a minimum on-site system blended with a remote working one. And the result of this in a no too distant future could mean that some collective bargaining agreements will change and will regularize the remote working system on its own content. And now, when is it going to be applicable? we could split this section in two parts. First, for those companies with remote working agreements, actually, and for those without teleworking agreements. For the companies with remote working agreements, the new law will be of application to the existing employment relationships, regulated by private agreements for remote working from the time that it expires. If there is no expiration date of these existing teleworking agreements, it will be of application 1 year after the publication of this law on 3rd this October. This year can be extended up to 3 years through an express agreement between employee and an employer. And as told before, the implementation of the law cannot affect the labor conditions of the employees. So it could not be implemented with the objective of the absorption, equalization, or elimination of any right and more beneficial condition that the employee has been enjoying because of a prior agreement. Then for those companies without remote working agreements, it's compulsory to reach an agreement with the employee during the next 3 months from the application of the new law. Yes, but what about the remote working systems implemented during the COVID-19? Well, so the new regulation does not cover remote working implemented in light of COVID-19 containment measures. While this measure continues, this work will continue to be subjected to employment regulations, ordinary regulations, and the companies in this provisional situation must still provide the means, equipment, and tools, although they are not required to compensate expenses. Rules on compensating expenses, as told, may be established on the collective bargaining. So, based on what we have seen until now, that this has been a lot of sudden information, it raises the question, how we should start? Well, so the companies should start reviewing the existing individual agreements for teleworking and creating new internal policies to regulate jointly all the remote working system elements for all the company. It is compulsory to include a right to disconnect policy. It is the power of the employer to guarantee the restriction of the use of technological means during the rest periods. The company has to be clearly define the modalities of exercising the right to disconnect to avoid the high risk of informatics fatigue. Also, and related on guarantee of the right of non-discrimination on ground of gender, the companies will have to review or create the gender equality plan and adopt the protocol to prevent psychological and sexual harassment. It's important to consider that here in Spain, those companies with more than 115 employees are forced to have implemented a gender equality plan. This number is going to be increased from March 2021. That will be of application to the companies with 100 employees and extending the application of this law on March 2022 to the companies with more than 50 employees. And with this section, we finalize our presentation. We really hope you all enjoyed it and that it could serve to clarify the key topics of the new law. Thank you for your participation, and we come now to question time.
Okay, thank you very much, Clara and José Luis. Let's see if we have some questions. I don't know if there are any questions of the participants. Yes, Ramesh, you can unmute your microphone. Thank you.
Yeah, Christina, well, this presentation is really good and very effective. And I have one doubt. This remote work, it's forever or only for the pandemic? What is the plan for the country? What is the decision by the government? it's for some period, like a pandemic is over. Might be once they find that medicines, might be this COVID will get over. I think so. Might be next year. So the law is valid up to next year, or it's forever.
Well, it could be said for a short time for the between the employer and the employee. In the writing agreement, both parties could fix a duration for the teleworking, and even if both parts decides to fix this remote working system for, I don't know, 3 years or for 5 years, and after this time both parties decides to review the system, it could be great with no problem.
Okay, yeah.
It's not just only for COVID-19. It's after that, the COVID-19 remote working. It's not connected with this new measure.
Yeah, that's true. Yeah. Now, yes, one more point. I have a doubt. One more point. These instruments, working elements we want to provide to the employees, no?
Mm-hmm.
Like we are providing like computer, internet, telephone connection we are providing in the office. The same thing we need to provide in the telework as well. Am I correct?
Yes.
Okay. So, see, my question, we can provide, or they can also buy and they can reclaim us that expenses. It's possible. Say if might be their house, they have internet connection. So what want to give internet connection, might be they can share, might be okay, I can spend like 20 euro per month. Might be they can claim us. That's also we can do it in this contract or not possible.
Yes, it can be established in the agreement, and the employees could choose to be paid for the invoices from the company, or just to ask to the company for the means of the work jobs of each one.
Okay, so like the computer also as well. So might be they have own computer in the house, they have internet, they have telephone connection, so it's not required, a company not required to provide all these instruments, no? It's only agreement between employee and employer. Am I correct?
Yeah. It has to be with between agreement with both parties.
Okay, fine.
Thank you very much, Ramesh.
Thanks, Christina.
We have a question from Alexandra. Thank you for joining us. And either for Clara or Jose Luis. In the case we would normally not offer remote working for more than 30% and only use remote working during COVID-19, we would not need to do anything?
Yes, exactly. This is one of the things that you should take into account, no? That there is an exception of the application of this new regulation. The Royal Decree stipulates that the companies that have adopted the telework because of the pandemic are not subjected to this new regulation. So that means that you don't have to sign the agreement with employees, or, for instance, you don't have to compensate the cost. You have another obligation, of course, because you have to give the tools and all the means to the employee to develop the work. But for instance, you are not obliged to sign the individual agreement with employees. And also, if the company didn't adopt the telework because of the COVID, but you are below the 30% of telework in 3 months, you are not subjected to this regulation.
Okay, thank you, Jose Luis. We have Frank that raised his hand. Frank, you can unmute your microphone.
Hey, good morning. This is Frank from Vestex. Following Ramesh's question here about the equipment, is there a defined catalog of minimum equipment items? I mean, we talked about an internet connection, about a computer, and maybe a monitor, so technical equipment. But what about a desk, a chair, a printer? So an office is more than just a laptop. So is there a specified minimum catalog of items that we have to provide?
Well, there's no extended list of the means. It will depend on each activities of the companies, on each job requirements. The law does not establish a fixed list, so it will depend on what employer and employee agrees in the agreement.
Yes, this is a law of minimum. As most of the regulations will be improved with through the collective bargaining agreements, or in case that the company have a worker representative through the negotiation with the worker representative. But in lack of this representative, through the policy or that the company established about the telework and finally the individual agreements.
Okay,
but as explained, Clara, there is not a detailed list of the equipment that the company have to provide to the employees. The same with the compensation. The law only says that the company will have to compensate the employees for the cost derived of telework, but don't say how will compensate and what have to compensate. This will be regulated later by the collective bargaining agreements.
Yeah, it has to be established on each individual agreement between the employee and the employer, and accordingly to what both parties agreed.
Yes, but in case that you adopt the telework more than 30% in the individual agreement, you have to stipulate. This is a legal requirement. You have to stipulate an inventory of the means, equipment, and tools.
Okay, we are a technology company, so we definitely have more than 30% of our staff working remotely permanently, like also in non-COVID times. What I understand is that we are free to draft the policy and also to agree with our employees on terms and the compensation, whatever that may be, unless it is at any time later. I mean, if the collective labor agreement gives some standards, which may happen in the future, this would change also our individual agreement. I mean, this could be, right, if we say, okay, we give you a computer and a phone and an internet connection, and then the CBA says, okay, but you also have to provide a chair and a desk. We might have to upgrade our agreements in a year's time, or whenever the CBA gives additional details.
Yes, exactly. Now, with the current regulation, you have to sign an agreement with the employees.
Yeah.
But you can stipulate what you want. Okay, what you agree with the employees. For instance, you can decide to compensate them with 50 euros per month, for instance.
Okay.
But if later the collective bargaining agreement stipulates that the compensation is 30 euros, for instance, you will have you will maintain the agreed with employees. Or if or another case, if the collective bargaining agreement stipulates that you have to compensate for the electricity, the Wi-Fi, any other expense, you have to incorporate this new regulation to the individual agreement.
Okay.
But nowadays there is not this regulation. We have only to follow that is stipulated in the Royal Decree 28.
Thank you.
Christina, you are on mute.
Oh, sorry, sorry. Felicia, just to confirm that we will be sending the slides. And then there's another question that says, for a company without remote working agreement, we have months to sign now agreement with employees. Is it right? During this period of time, can employees do remote work?
Well, if the company wants to implement the remote work system, then the company and the employees have 3 months from the application of the law to reach these agreements. But if the company does not decide to apply this remote working system, it's not compulsory to reach these individual agreements. It will depend on the system that the company opted to imply. If it wants to apply the remote working, it's right, but if not, it's not a must.
Okay, thank you very much. Does anyone else have any specific questions? As Jose Luis was saying, as this is a very new law here in Spain, there are many doubts, and this law just came into force. For sure, in these next couple months, upcoming months, and probably year, there will be many changes and many updates to this to this law.
Yes, from the Labor Department at Bové Montero, we will maintain you updated on this law or on any other law, because as you know, the government published many labor regulations during this year, and we will try to update you. But regarding this new regulation, that the most important is you have to know is that if you are have implemented the telework because of the COVID-19, you are not subjected to this new regulation. This is the most important. But in case that if this is not the case, you don't have a previous individual agreement with employees, you have 3 months to reach this agreement and to sign this agreement with employees, because this agreement must be registered before the employment office. This is a legal requirement, so this is compulsory.
Thank you, Jose Luis. There's another question from Alexandra, and she asks, will you have templates for agreements that comply with the new regulation?
No, not now, but we are working on it, of course. Yes.
Yeah, we can adapt the agreements between the employees and the employers and fix it in a physical agreement, adapted to the will of both parties.
Okay, perfect. Okay, let's see if there are any specific questions, and if not, we'll be able to end the session. I don't know, Jose Luis or Clara, if there are any during these 20 days that they announced this new law, if there are any recurrent questions. Probably you already revised them in the presentations, but any maybe recurrent questions from clients, or maybe they've already come up, questions that always come up. Okay, Alessandra, there's a question.
Hello, Alessandra from the Netherlands. Do we need to update and amend the employment agreement, or we just need to issue a new complete agreement?
Well, if
so just amend the employment contract of each colleague, or issue a new agreement, so a new document?
No, the employment contract don't change, that you have to do is to do an addendum
Okay,
or
to the contract.
to the contract to regulate this matter, the telework, if it is the case. But the initial contract
Should be the same.
Yeah.
that should be the
Okay.
same. Don't change.
Will not change. Yeah.
Okay.
This is the same if when you change any employment conditions, you have to do an addendum.
Yeah, right.
Because this is the same case.
Okay. And I was thinking about our employment contract for Spain, and in the place of employment clause, we have the employee can either work from the office or can also perform his duties in such other place or places as the employer may from time reasonable direct. So it means that we are very flexible with our employees. So is this, in your opinion, enough for us, or should we amend issue this amendment?
If employees develop their work working remote in more than 30%, you are obliged to sign this agreement with the employees.
Okay.
This is the point.
This is mandatory. Okay.
30% in a period of 3 months. If they work more than this percentage, it's mandatory to reach this agreement. Of course, if you don't do it, you have the risk that in case of a labor inspection of a claim from an employee, that you will have to do it mandatory, or you can have any sanction from the labor inspection. So
Okay.
this is mandatory.
Okay, perfect. Thanks.
Okay. Let's just see if there's any last questions. If not, either that either Clara or Jose Luis or our team in Madrid, you can also reach out to them if you have any other specific questions that come up after the session. So just thank you all for your time this morning, for joining us in this session. And then in a little bit, we'll be sending you a copy of the presentation and also the link, just in case you want to just see the webinar again or share it with any of your colleagues. So thank you very much to everyone for attending. Have a great day.
Okay. Thank you.
Thank you so much.
you.
Bye.
Thank you.
Have a great day.
Thank you.
Bye.
Goodbye. Thank you.
Bye-bye.
Bueno.
Muchas gracias, que estaba por aquí y no he dicho nada. Gracias a todos,
Gracias a ti, Reyes.
Gracias por conectarte.
Sí, por eso digo, me voy a conectar un momento, que he estado por aquí, lo que pasa que estaba entre mil cosas, pero ha ido muy bien, porque con 4 pinceladas lo habéis dejado todo muy claro. Y sobre todo el hecho de que es voluntario, que cuando se oyó por la tele parecía que es que iba a ser como obligatorio que todas las empresas hicieran teletrabajo o lo ofrecieran. Y el punto de que es voluntario por las dos partes, pues también es importante. Y que no es en el ámbito COVID, sino precisamente que se ha sacado aparte del COVID, ¿no?
Sí, precisamente la parte COVID está fuera de esta norma.
Sí, es curioso, porque la gente piensa que lo han sacado ahora para regular tema COVID. No, perdón, es que...
Precisamente lo contrario.
Exactamente. Pues muchísimas gracias por todo, Me alegro de veros y que vaya bien.
Igualmente, Reyes. Y
Venga,
cualquier cosa ya sabes, puedes contactar con nosotros, Mercé, con Luis,
sí,
y os ayudamos en lo que necesitéis.
sí, estamos siempre en contacto y la verdad que todo perfecto. Gracias por todo. Que
Venga,
vaya bien.
un saludo.
Adiós.
Encantada, buenos días.
Adiós, buenos días.
Adiós.
Adiós.